Hello, EDU200, and welcome to my presentation on school law. There are a couple of legal issues I'm not going to discuss here. The first is Public Law 94-142, originally passed in 1975. It was later renamed IDEA, Individuals with Disabilities Education Act. I'm not going to discuss that here because we covered it earlier in the semester when we covered special ed. I'm also not going to discuss what your legal responsibilities are regarding your need to report suspected child abuse and neglect. We have covered that, and you have all been through the training. Corporal punishment is the practice of spanking or paddling a child for misbehavior. I'm not going to discuss that either, other than to say it's illegal in the state of Virginia. Don't do it. Copyright laws are by far the legal issue you will confront the most, probably daily. It's quite complicated, but I have posted a video on that separately from this presentation. Public school law and ethics can be boiled down to things you can do, which are your legal rights, things you must do, which are your legal responsibilities, and things you should do, which falls into that sometimes ambiguous context of professional ethics. Laws are often purposely stated in general, even vague terms, so they can be applied to a variety of situations. It would be literally impossible to write a law for every specific situation that arises in schools, or life in general for that matter. That is why we as a society must be careful what we consider lawful or not, because once a precedent is set, that case will be used to justify other cases. For example, in 1849, in the case of Roberts versus the City of Boston, the Massachusetts Supreme Court ruled that the Boston public schools could deny enrollment of African American children to the segregated whites-only schools. The case is later cited as a precedent for the Plessy versus Ferguson case in 1896. In Plessy versus Ferguson, Plessy challenged the state of Louisiana's Separate Car Act, arguing that requiring blacks to ride in separate railroad cars violated the 13th and 14th Amendments. It went to the Louisiana Supreme Court and then to the U.S. Supreme Court, which upheld the Louisiana law, ruling that separate but equal policies are legal. It became the legal precedent used to justify many other segregation laws. It wasn't until over 100 years later, in 1954, that the U.S. Supreme Court announced its decision in the Brown versus Board of Education case, ruling that separate educational facilities are inherently unequal and therefore unlawful. The First, Fourth, Fifth, 10th, and 14th Amendments to the Constitution have implications for your teaching. The First Amendment issues free speech. However, how strongly you can publicly criticize your school principal, well, that's uncertain. By the way, freedom of speech is really freedom of expression, and that includes your appearance as well. Now, the school has the right to limit that to some degree, too. A student's appearance can't be distracting to learning, so t-shirts promoting alcohol or extreme hairstyles or revealing clothing can be banned. The Fourth Amendment protects citizens from unreasonable search and seizure. A student's property is his, including his locker or backpack or the car out in the parking lot. A school official must have reasonable cause before the student's property can be searched. That means there has to be enough circumstantial evidence and possibly a track record to justify the search. The 10th Amendment helps to define the concept of federalism, the relationship between federal and state governments. Essentially, the 10th Amendment states that anything not covered under the other amendments is a states' rights issue. But over time, as the federal activity has increased, so too has the problem of reconciling state and national interests. If you look closely at the founding documents, there's nothing in them about education. I believe the founding fathers did that intentionally, not wanting to have a national system of education that controls the way its citizens think. They intentionally left it to the states to determine how best to educate its own citizens. And at that time in history, each part of the country had its own unique needs. The needs in the South, which was rural, was different from the more industrial states in the North. Both the Fifth and 14th Amendment guarantee due process. The fact that our founding fathers included this twice in our Constitution speaks to the importance and value of this concept. It starts with assuring that everyone is considered innocent until proven guilty and is entitled to due process. Due process requires that the person charged has the right to a written notice specifying their charges, access to the evidence and names of witnesses, a hearing conducted before an impartial decision maker, the right to representation, a school board decision based on the findings of the hearing, and a written record of the hearing and the right to appeal. So this would be true for students before they can be suspended or expelled, and it's true for teachers before they can be let go as a form of disciplinary action. I'm not going to take the time to review the requirements for becoming a licensed teacher in the state of Virginia. We covered that earlier in the semester as we discussed your licensure plan. Collective bargaining is the process that occurs when professional organizations, like a union, negotiates teachers' rights and working conditions with the local school district. Collective bargaining allows teachers to file grievances if they believe conditions of the contracts have been violated. Virginia is a right-to-work state, so there really isn't a powerful teachers' union like there are in some other states. Now, labor unions were incredibly important and powerful in our nation's history. Unions began forming in the mid-19th century in response to the social and economic impact of the Industrial Revolution. More and more workers were needed, and many more factories had become sweatshops with horrid working conditions. Unions worked to increase the pay and improve working conditions for workers. Today, collective bargaining has become politically controversial. In 1981, when 13,000 air traffic controllers went on strike, then President Ronald Reagan ordered them back to work within 48 hours or be fired. Many were fired. In Wisconsin in 2011, legislation was passed taking collective bargaining rights away from public employees, including teachers. It is interesting that in West Virginia last year, 2017-18, the teachers went on strike and started a small rash of teacher strikes around the country. But this time, not only were they striking for increased pay and benefits, they were striking for more funding to be put into education, for everything from building repairs to police security to supplies. Virginia doesn't have tenure, but so you know, teacher tenure is a legal safeguard that protects teachers from dismissal without due cause. Tenure is also politically controversial, with critics arguing that it protects incompetent teachers and proponents arguing that teachers need protections. The trend across our country is toward the elimination of teacher tenure. So other than working in Virginia, which doesn't have tenure, if you move to another state that currently has it, it may not when you get there. Pause the video and read through this scenario and think about it. When you're ready, restart the video. Yes, this issue falls into the domain of academic freedom. Assuming that your grading system is consistent with the accepted practice in the school and district, the suit is likely to be dismissed. Courts rarely intervene in issues involving grading. The idea of academic freedom means that although the state may tell you what to teach, in Virginia those are the SOLs, you as a teacher get to determine how you will teach it. Teacher notoriety. These are issues that have come up before the courts before too. So go ahead and stop your video, read through these 7 brief scenarios and decide for yourself, and then start the video. The answers aren't always clear, and it can vary from school division to school division. Let's take these one at a time. Number 1, lifestyles in our country have evolved, and being dismissed for living with a boyfriend or girlfriend is unlikely. Number 2, assuming you aren't arrested for being disorderly, you are unlikely to be dismissed just for partying. Number 3, a sexual relationship with a student is absolutely forbidden and is a sure route to dismissal and loss of your teaching license, not to mention a felony. Number 4, this is slightly a gray area, but you may be dismissed for a DUI, particularly if it becomes well known. Number 5, this is a slightly gray area as well. The simple solution is don't do it. You can just as easily go home and avoid the possibility of the controversy. Little point exists in asking for trouble. Number 6, you are likely to be dismissed for being arrested for shoplifting, especially if notoriety is involved. Whether the jewelry is expensive or not is irrelevant. And number 7, at one time in our country's history, you would have been dismissed for being gay or lesbian, but that is now not likely and illegal. Neither you nor your school can officially encourage student prayer. It is permissible, however, when initiated by a student and when it doesn't interfere with other students or functioning of the school. You may not officially use or display religious symbols, such as a portrait of Jesus or the Ten Commandments, in your classroom. You may wear religious symbols as long as they are not distracting, such as a Star of David necklace or a hijab. You may include discussions of religion, such as the history of religion and the role of religion in our nation's history, as part of your curriculum if you treat the topic objectively and don't advocate one religion over another. Religious clubs are allowed to access the school facilities if they are not school-sponsored or initiated. Sexual harassment falls into the gray area in the context of can do, must do, and should do. For all intents and purposes, legal precedent in cases of sexual harassment really don't exist. Although with the hashtag movement, this is changing. The question of what you must do is unclear. On the other hand, what you should do, your professional and ethical obligation, is clear. You should clearly communicate that sexual harassment in any form will not be tolerated and that the school you work in is a safe place for all students. By the way, boys can be sexually harassed too. And let's try to remember the idea of due process and presumption of innocence. The Buckley Amendment is the name commonly used for the Family Educational Rights and Privacy Act, FERPA. FERPA is a federal act that makes school records accessible to students and their parents. Under this act, the school must inform parents of their rights regarding their child's records. They must provide parents access to the child's records, and they must maintain procedures that allow parents to challenge and amend the information that's in those records. They must protect parents and the child from disclosure of confidential information to third parties without their consent. Do you remember exchanging spelling tests in school so you could grade one another's tests? If the goal of FERPA is to protect the integrity of a student's academic records and the privacy, do you think it's legal to exchange tests like that? I look forward to a robust discussion.